Good afternoon, everybody, and welcome to our webinar in collaboration with Intercontinental Trust and Andersen. My name is Sarah Simson, and I am the head of Fiduciary at Sasfin. We are glad you could join us for this panel discussion on the use of Mauritius Trusts and the suitability of these trusts for South African residents. We've really been receiving a myriad of questions on electing an offshore jurisdiction for the setting up of trusts. So I think firstly, it needs to be said that we are jurisdiction agnostic and we are neither for or against any jurisdictions. We are really not experts on this matter. So today we bring you the experts on the topic. Now, this session is really intended to give you a little bit of insight into some of the tax changes that we have been seeing and to give you a bit more clarity on a number of matters that have been gaining media attention and to just clarify the practical application of certain legislatory changes. Joining us today is a panel of esteemed colleagues in the industry who will be sharing the insights with us. Now, their full biographies are to be found on the initial invitation that was sent out. I'm afraid that showing the full extent of their qualifications and experience could take quite a good part of our time. So in the interests of time, my introductions will be brief. We are privileged to have Fazeel Soyfoo joining us today. Fazeel is a partner at Andersen in Mauritius, and he specializes in international tax structuring. Welcome to today's discussion, Fazeel.
Thank you, Sarah.
We are pleased to have Ernest Marais with us today, who's an international tax specialist and a director at Andersen, South Africa. Ernest specializes in corporate and tax law, and he advises on cross-border tax structuring amongst other specialities. Welcome, Ernest.
Thank you, Sarah, and thank you for having me.
We also have Willem du Preez of Intercontinental Trust joining us today. Willem is an executive director at Intercontinental Trust. He heads up the South African Representative Office and he focuses on assisting South Africans with their requirements for global expansion. Welcome to you too, Willem.
Thank you very much, Sarah. It's a pleasure to be here.
Fazeel, I'm going to start with you. Most of us are aware that the Financial Action Task Force listed Mauritius on its grey list, and the European Commission also included Mauritius on the EU's AML blacklist. Please, can you take us through what has transpired since, and how does this now affect Mauritius's position as a jurisdiction in the global financial services industry?
Thank you, Sarah, and thanks again for having me here. Indeed, that Mauritius was put on the FATF, the Financial Action Task Force grey list, back in March last year. And then subsequently in May last year, we found ourselves with a bit of a surprise on the EU blacklist. The cause for that was some strategic deficiencies that were identified within the Mauritian AML and CFT framework, anti-money laundering and countering the financing of terrorism. The EU blacklist had an effective date of 1st of October 2020. So we've been on that for just over a year. But since then, a lot of things have happened and a lot of positive things have happened. Action plans have been set up at various levels and at the highest levels of the authorities and the regulators and the government in Mauritius. New legislation has been published. There's been new education and training and awareness campaigns, and certainly new supervision and new enforcement measures. Basically, the whole industry went through a phase whereby we had to up our game when it came to regulation and regulatory compliance. These bold policies and measures paid the dividends. Insofar as only last month, we got the good news from the FATF that Mauritius had to be removed from the grey list. We were on the EU naughty, the UK naughty list as well, and that as well has been removed. We are only waiting to be removed from the EU blacklist now, which apparently is a formality. I only heard yesterday in the news from one of the directors of the commission, the Financial Services Commission here, saying that this is a formality and it's going to happen, imminently. I mean, this sort of cloudy or dark phase for us has had some consequences, but at this point, when we look back we see benefits in the sense that I think we certainly come out of this situation a lot stronger. You know, Mauritius today, as a financial center, is in a position where it finds itself a lot stronger, a lot more resilient, a lot more confident to face the challenges of the future, because we know that our standards when it comes to regulatory compliance is a lot better than what it was, you know, a year and a half ago. And I can draw parallel with the situation with regard to our tax system, because 4 or 5 years ago, those of you who have been following the jurisdiction will know that we faced similar challenges from the EU with regard to what they call harmful tax elements in our tax system. Since then, we've got rid of those, and again, you know, this has given us confidence to sort of to plow ahead. So the short of it, Sarah, is that today, I think the jurisdiction is a lot stronger. Certainly, when we get the official seal from the EU that we've come out of the blacklist, it will give a boost to the jurisdiction that we are a lot more confident going into the new year and going into this new phase.
Thank you for that, Fazeel. Now, we've had so much contradictory information on the tax changes to Mauritius Trusts in the last year. Previously, we understood that a Mauritius Trust could file an annual declaration of non-tax residents to be exempt from Mauritian tax. And it was as simple as that, really, for us. The changes have left many of us really unsure as to whether or not Mauritius Trusts with South African settlers or beneficiaries will be subject to tax in Mauritius. How has this common misconception been clarified recently?
Thank you, Sarah. And indeed, this has been a question that's been cause for concern for many people in South Africa and elsewhere. And let me try and explain it, because I don't think that at the end of the day, the situation today with the change in law that happened and the statement of practice that was issued by the tax authorities, it's not all that bad. So what happened was that in the Finance Bill 2021, so earlier, you know, a few months ago, there was a proposal for to change some of the laws, taxation laws with regards to trust in Mauritius, and in particular one element, which is the annual exemption or declaration of non-residents, that was basically going to be removed. It came as a bit of a surprise because it wasn't mentioned in the budget. And it certainly left a lot of people questioning the reason for that and the consequences for that. And there was a phase, I must admit, where there was a lack of clarity around how these rules will pan out. But then subsequently, the tax authorities came up with a statement of practice to explain sort of this change and how it's going to be implemented, at least by them, in practice. So just if we take a step back, in Mauritius, a trust is considered resident if it's administered in Mauritius, so a majority of trustees are based in Mauritius. And typically the trusts that are set up, they are administered in Mauritius, and typically we usually have one trustee, which is a trust company in Mauritius, or what we call a management company. So by and large, the trusts are resident in Mauritius. Now, in certain situations where there are trustees, whether the settlers and the beneficiaries are not resident in Mauritius, there is an exemption. There's a carve-out in the law which allows the declaration to be filed, claiming and to the effect that these trusts will be non-resident in Mauritius, and thereby they become exempt from tax in Mauritius. What happened was that this declaration, or the option to make that declaration, was removed. And therefore, trusts that were set up in Mauritius couldn't do that declaration anymore, although there was a grandfathering, and there is a grandfathering period of 3 years that's been allowed. Since then, the authorities have come up with a statement of practice, and perhaps I can share it on my screen here, and just to perhaps for the audience to follow the changes better, because some of it can be a bit confusing. So prior to Finance Act 2021, resident trusts were subject to income tax in Mauritius at 15%, subject to exemptions and reliefs. But those qualifying trusts, as I've mentioned, where the settlers and beneficiaries were non-residents, could file an annual declaration of non-residence and be exempt from tax in Mauritius. Okay. Now, following Finance Act 2021, there's a repeal of that declaration exemption. The grandfathering period goes until 2024 and 2025. However, there's a carve-out to the grandfathering whereby income derived from certain intellectual property assets and other specific assets could still be subject to tax based on certain criteria. And then that left an uncertainty which needed to be clarified. So in comes the statement of practice. What this statement of practice does is that it introduces the concept of management and control for a trust, which didn't exist or doesn't exist in the law. And this is a new sort of concept, and it's only in this statement of practice that we will see the details of it. So what the statement says is that for a trust to be considered resident in Mauritius, it has to be managed and controlled from Mauritius. And to be managed and controlled from Mauritius, there are three criteria that have to be met. And these are number 1, 2, and 3 that you can see on my screen. So number 1, the trust has to be administered in Mauritius, and a majority of the trustees are resident in Mauritius, which typically happens. Number 2, the settler has to be resident in Mauritius. And number 3, a majority of the beneficiaries have to be resident in Mauritius. Now, typically for trusts set up by South Africans, by non-residents, the settlers are not resident in Mauritius, and the beneficiaries are not, and more often than not, they're not resident in Mauritius. So through this statement of practice, what it has achieved, it has somehow, again, put those trusts that otherwise would be filing the declaration for non-residents in a position where they're now considered not resident in Mauritius, because they're not managed and controlled from within Mauritius. Now, this is not exactly the same as it was before. Yes, in the new setup, such a trust set up by a South African settler with, let's say, South African beneficiaries is considered non-resident in Mauritius. However, it doesn't benefit from the exemption, the blanket exemption that trust previously had through the declaration that they would file every year. By virtue of being non-resident in Mauritius, what that means is that the trust is not subject to tax on any foreign income derived by the trust in Mauritius. However, if the trust derives an income from within Mauritius, that income could still be subject to tax in Mauritius, unless it's got some special characteristics. For example, it's exempt, such as local dividends. So, Sarah, hopefully that paints a bit of the picture, and I'm happy to discuss it in more detail through, maybe an example. But this is the essence of the change that has happened through the Finance Act and subsequently clarified through the statement of practice to essentially bring everyone into a position where all those trusts that would otherwise be non-resident are still considered non-resident. However, there is no blanket exemption, and local income derived from within Mauritius may now be taxed in those trusts going forward.
So I think, Fazeel, for the interests of our audience here today, do you mind to simplify that? That was a lot of legalese. Do you mind to put that into an example or a scenario? Maybe simplify it to a trust set up in Mauritius, and that trust purely has a portfolio of shares, and perhaps contrast that with a situation where that trust also has a property in Mauritius held by the very same trust.
Sure. The essence of it is that if you've got a trust in Mauritius, and again, we are assuming the settler is non-resident and the beneficiaries, and most of them are non-resident, okay? So the trust qualifies under the statement of practice as a non-resident trust, okay? That's the starting point. Now, if that trust receives or generates any income from foreign sources, let's say it holds shares in South Africa, in portfolio shares in Europe, in anywhere other than Mauritius, then the income received in the trust is not subject to any tax in Mauritius. It's as straightforward as that. The moment we have to be concerned, or at least give it a bit more consideration, is when income is derived from within Mauritius. And let me give two examples. One example is where the trust holds shares in a company in Mauritius. And again, that's a typical scenario where the trust could be holding shares in a GBC company in Mauritius. Now, that GBC company pays some dividend to the trust, even though this is local income because it's from within Mauritian sources. We know local dividends are exempt, so there's no tax there. Now, a different scenario where the trust, let's say, holds property in Mauritius, say directly, and the property generates rental income. That income would be subject to tax in the trust. And likewise, other income that's generated from within Mauritius would be at least within the scope of taxes, as opposed to previously, there could be a blanket exemption for all income generated in the trust. So that is the main difference. And I know there have been some changes in South Africa and the looping rules. So the trust, I mean, if I can re-emphasize or at least give further comfort that the trust, as it is today, with the clarification provided through the statement of practice, is as attractive as it used to be, and a lot of the misconceptions that have been brought in through either miscommunication or through media and newspaper articles, I don't think they've done justice to the statement of practice that have been issued to explain clearly what are the changes and how they impact the trust going forward. So I'm with the knowledge, with the reassurance that we can give, I think it's safe to say that Mauritius remains very attractive for South Africans to set up trusts in Mauritius.
Thank you for clarifying that, Fazeel. I think now that we understand the tax changes a little bit better, we can explore how South Africans go about transferring assets into trusts. And I think we would need to consider exchange control. You already mentioned loops, and Ernie, I think I'm going to turn to you for this one. I would really like to explore the issues around the current exchange control regime in South Africa, and more particularly the relaxation of the regulations pertaining to loop structures. So I think to start, please can you share with us what the restrictions were and how those have been somewhat reduced?
Thank you, Sarah. Yeah, so it's obviously, there's been quite exciting movements in the South African exchange control regulations over the last couple of years. So just to give some background, prior to 2019, South Africans weren't allowed to have what they refer to as a loop structure. Now, a loop structure is basically if a South African resident holds an interest in a foreign entity, and that foreign entity then in turn holds South African assets. So it's a South African exchange control resident which holds South African assets indirectly via a foreign vehicle or foreign entity. In 2019, there was a slight relaxation in our exchange control regulations in the sense that the Reserve Bank says South Africans can hold up to 40% in a foreign target, which in turn holds assets in South Africa. And then at the start of this year, to the surprise and yeah, it was all met with great excitement to us all. They finally completely relaxed the exchange control regulations and said South Africans are now allowed to hold up to 100% of an interest in a foreign target, and then that foreign target can hold assets back into South Africa. So what this has allowed South African residents to do is to move some of their South African-based assets into their foreign entities. There are obviously still restrictions that's applicable to in order to benefit from this, and it's quite highly regulated. And I think there's the three key requirements that will need to be met in order to invest in the loop structures. First of all, the South African resident will need to show that they've obtained approval that the funds that they've used to acquire the foreign entity was legitimate funds. Those funds have been you've either taken the money out through your foreign discretionary, your foreign capital allowance, your single discretionary allowance, or it's foreign earnings that you're retaining abroad. So that's the first key thing that you'll need to show. The second thing is you need to show that all South Africans' assets are required at fair market value, and the Reserve Bank very often requires an independent valuation from the auditor to confirm that the assets are being required at fair market value. And then lastly, you need to show that there's actual foreign currency flowing into the country, so that that the money to acquire those assets actually flow from, be it Mauritius or wherever it may be, into South Africa. So those are the key. I understand those are the three key requirements that need to be met in order to get approval.
Thank you for that. That is truly exciting news. But I think, would you like to delve a little bit further into the opportunities that this has created for South Africans wishing to move assets abroad? You may just wish to touch on some tax, or otherwise just look at some consolidation of assets into alternative jurisdictions.
Thanks, Sarah. I think the rationale behind why the South African Reserve Bank's done this is to encourage investment into South Africa, and I think we got to a point where a lot of people were getting concerned about economic risk in the country, and they obviously, as one does, they took a lot of funds, a lot of capital out of the country. The issue was the ability to access that capital once it's been moved. Like I said, now what we see people doing is people saying, listen, I'm going to take out my 10 million rand per annum foreign capital allowance, and I'm going to take a portion of that, invest a portion of it in passively offshore, and use a bit of, and if the opportunity arises, at the end of the day, the entrepreneur is still in South Africa, you can still see the opportunity in South Africa, and then use a part of that portion of the funds to invest back into your business into South Africa. A lot of people are doing an outright sale of the South African companies. They're doing an outright sale, selling the shares of the South African company currently held by them personally into their foreign target. The issue which very often arises as a result of this, firstly, is a question of liquidity, because you need to pay fair market value for those shares, and then of course the capital gains tax impact that it may have on the acquisition of such shares. Now, there are numerous ways on how to structure your acquisition of your local entity to minimize these issues, and to just from a cash flow point of view, be it from a cash flow point of view, CGT point of view, there are ways to go about it. Once you've acquired, let's say, shares in South African entity, if it's held directly by a Mauritian trust, which is considered to be a non-resident, there was obviously a withholding tax on any dividends flowing from South Africa to Mauritius, because obviously a non-resident trust will not qualify for will not be able to rely on the double tax agreement between South Africa and Mauritius. If there's a holding entity interposed between a Mauritian holding entity interposed between the Mauritian trust and the South African company, then that withholding tax may be reduced in accordance with the double tax agreement up to 5%. Like I said, you obviously need to have a commercial rationale for setting up that entity and setting up those structure other than the obvious tax benefits that's applicable.
So I see a question just came through from one of the attendees, and I think this is probably a good opportunity to delve into this a little bit further. You did touch on it. I heard you mention capital gains tax. I heard you mention dividends. So you may wish to answer this from a commercial rationale perspective, or alternatively, you might want to go into tax. Being a tax attorney, I think that would be what would excite you here. And the question is, how does it benefit you to have your South African assets owned by a Mauritian entity?
It allows you to, so let's look at it from it allows you to move dividends offshore without having to utilize your foreign capital allowance every single time you want to move money out of the country. And also you need to remember your foreign capital allowance is usually funds that's very often paid from your company. It's moved into your individual name. you're paying your 20% dividends. It's after tax money that in your individual capacity you then move it into, and then you need to move it into a structure in Mauritius again, and then you're obviously then we're looking into do you loan it into the structure, do you acquire the assets? So that's the first thing. It allows you, it enables you to move money from your South African entity without moving it into your personal capacity first and then moving it out of the country. It allows you to move money directly from a South African entity into your Mauritian entity.
But Sarah, I think perhaps if I can add a bit into that for Uni as well, I think one of the important things that we've seen over the last number of years is clients want to have a single trust or a single point where all their assets are accumulated. And I think the challenge that we have in South Africa at the moment is that exchange control does not allow us to have our trust own foreign assets elsewhere. You can interpose a holding company, and the holding company can apply to the Reserve Bank to own foreign assets, but there is restrictions on what foreign assets can be owned. The one opportunity that this looping has provided is for clients to have a single vehicle that owns all their assets globally. So the offshore trust can now invest back into South Africa, and it can own assets in South Africa, and it can also own foreign assets. And that truly allows families to do proper estate planning and put proper asset protection mechanisms in place to ensure that the assets are consolidated in a jurisdiction. And I think if we look at it, that's probably the single biggest benefit that this has provided. And in addition to that, there's obviously all sorts of various other benefits that can be explored.
Thank you for that, Willem, and thank you, Ernie, for that explanation. Now, just looking a little bit at the estate planning angle. At Sasfin, we believe that your estate planning strategy is as important as your investment strategy. And many clients absolutely cringe at the costs of externalizing assets. So, for example, the capital gains tax, which is a proper grudge tax. And they consider leaving South African assets to offshore trusts in their wills, rather, so that tax is only payable on death. Ernie, you may wish to sit on the fence regarding this question. It can be quite controversial, and there seem to be quite diverse views on bequeathing South African assets to offshore trusts. What do you think about this strategy?
Yeah, thanks, Sarah. I thought we agreed no difficult questions today.
There's always a left field.
Exactly. Like I said, I am going to sit squarely on the fence here because it's a situation where there's not absolute clarity on it by the South African Reserve Bank. There's not the exchange control manuals and guidelines says that you are allowed. It says it's quite clear. It says that you are allowed to a South African resident is allowed to leave to bequeath assets to a non-resident, be it a non-resident company, non-resident trust, non-resident individual. They've set on certain requirements in terms of cash requests under 250,000. They've put quite a clear position on, and then they look at the customs and saying this, and all other assets should be dealt with as normally dealt with through the customs provisions. Now, where I'm going to, say that, so in theory, it's yes, you are allowed to do that. What we're not completely sure about is what's the position that's going to be taken if you want to externalize. On your death, your executor wants to externalize 30-40 million rand of assets and move that to a non-resident trust. Personally, haven't done an application like that. I'd be happy to do it, but I can't guarantee that it's that you'll get absolute approval. And it may be worthwhile approaching the Reserve Bank, the authorized dealers on this, and saying, listen, this is the last will and testament. Let's get that. Let's try and get a position on that now, prior to someone passing away, and then you're having all the issues, and then his heirs are sitting with all the issues of trying to sort out the exchange control issues.
I see that one of the questions that came up pretty much touches on this, so we are going to delve into that question. The question is, please clarify if the Mauritian Trust can hold assets in South Africa if the beneficiary and settler are South Africans. Fazeel, I don't know if you want to take that, or Ernie?
From a Mauritian perspective, Sarah, there are no restrictions.
Sarah, from a South African point of view, as I've mentioned earlier, yes, you're all allowed to do that. You just need to make sure that you comply with you just need to go through the formal application process.
Perfect. Thank you for that. So I think, we have considered the exchange control and tax implications a little bit. So let's turn to the actual trust itself. And for this, I think, Willem, you're going to be the best person to delve into the trust structures. In South Africa, we are very used to trust structures where we have an element of control. So we are the founder, we the trustee, we the beneficiary. And although we try to pretend we don't have control, we actually do have a measure of control. If anyone says that to us, we will deny it vehemently, but that is the reality. And a lot of South Africans are not used to this divesting themselves of control when they put their assets into an offshore trust. And it is an area of concern because they are the settlor and they actually just might be a beneficiary, but they are not a trustee. So essentially, South Africans are handing over their assets to these trustees that they may have met 2 months ago to manage on their behalf. What sort of security or surety measures are in place for South Africans feeling insecure?
Thank you, Sarah. I think there's a number of points that we need to look at. And I think first and foremost, what is very important to understand is that the trustees sitting on the other side are not just individuals that one day decided they wanted to be trustees. These are companies that are regulated by, for example, in Mauritius, the Financial Services Commission, and authorized by the Financial Services Commission to act as a trustee on a trust. So they're a qualified trustee, that you have to meet certain professional standards, and you have to obviously apply for the license, which requires you to have professional indemnity insurance. It requires you to have obviously the relevant competence and skills in the company, but also sufficient capitalization to qualify for the license. So we're not just entrusting everyone, we are trusting someone who a regulator has also given the thumbs up that they are an appropriate trustee or that they can act as a trustee on a trust or a structure. That's the first thing. I think the second thing that becomes important is the law that regulates this trust. Yes, it is in Mauritius, and Mauritius does have its own Trust Act, so the Trust Act of 2001. But very important to understand, the ultimate court of appeal in Mauritius is actually the Privy Council in the UK. So if something goes wrong in the trust, or if there is a legal dispute around the trust, you all ultimately have recourse back to an international court sitting in the UK in a jurisdiction that we all know and trust, hopefully, to debate or to settle the specific matter. So there is quite a bit of protection coming on it from the fact that we're utilizing common law, we're utilizing international tax principles or international trust principles. We have recourse back to an international court, specifically in the Privy Council, and that gives quite a bit of security. But the added mechanism to that, and something specifically coming up in common law trusts, which are different to South Africa, is this concept of a protector. So the protector is a fourth party to the trust. So the three parties to the trust is obviously the settlor, the trustees, and the beneficiaries, and the trust is a contractual relationship between the settlor and the trustees to manage the fund for the beneficiaries. But the protector comes in as a fourth role, and their role is clearly defined within the trust deed to which the trustees have accepted, that the protector can veto certain decisions the trustees make. And in addition to that, the protector can generally also request or replace the trustees. So they can request the trustees to resign in favor of another trustee. And importantly as well, that trustee could be another Mauritian trust, or Mauritian trustee rather, or it could be a trustee in another jurisdiction, which allows us to migrate the trust out of Mauritius as well, should something change within the jurisdiction that is no longer suitable for the specific vehicle. There is potentially tax consequences to such a migration, and it is important to take proper advice, but the protector does provide us with this mechanism. The thing that becomes important is we must make sure that the protector doesn't have too many powers, because that could make the protector a de facto trustee or impair the effective management of the trust to be brought back to wherever that protector is based. So it is a fine line, but this role of at least being able to remove the trustees and be able to veto certain important decisions, like, for example, addition of beneficiaries, removal of beneficiaries, disposal of major assets, those does provide the client with that protection mechanism and ensure that they can actually gain some level of control should there be a dispute between themselves and the trustees.
And you talked about the protector. Typically, who would this person be? So if you were considering who would be your protector, who would be the choice of the panel of people that you would be electing one from?
So a lot of clients want to be the protector themselves. I think it's quite aggressive if you are the settler of the trust, you're the protector of the trust, and you're a beneficiary of the trust. I always believe the protector should be someone that is around, that when you're not there, they can ensure that trustees have sufficient information to make the correct decisions. So it should be someone that knows the family very well. It does not have to be a beneficiary of the trust, but it could be a trusted advisor or someone that understands the family situation and are able to ensure that the trustees have the right information, as I mentioned, to make the relevant decisions. So financial advisor or a legal advisor or a very close friend or a family member like a brother or sister that isn't necessarily involved in the trust.
Thank you, Willem. You did touch on effective control and management a couple of minutes ago, and this would be a perfect time to deal with the one question that came through that asked if it is managed and controlled in Mauritius, is there not a question as to the management and control occurring through South Africa? So if you can maybe just take our listeners through what would the impact of management and control in South Africa be, and maybe just give us reasons as to why you don't want to be the protector.
I think the important part around this is that the trustees must always be in control of the assets and ensure that they are managing and controlling it from abroad. If that is the case and there's not anything that can pull the trust back in South Africa, there should be no reason why the trust should ever be considered to be managed and controlled from South Africa. So even though the trust may not necessarily trigger tax in Mauritius by virtue of this declaration of non-residence, the trustees ultimately are the people that are in control. They must be seen to be in control, and they must actually be in control. And if that is the case, then the tax residency should not come back to South Africa. And that does come back to that fine line that the protector cannot have too many rights, because that could essentially say that, well, they can just override the trustees, and hence the trust becomes taxable here. But importantly around the protectors, the protector cannot initiate the transaction. The protector cannot tell the trustees to do what they want to do. The protector can simply tell the trustees that once they've made a decision, that is not a decision that's in line with the rules and requirements of the family, and hence please don't proceed with that. And that ultimately is the role of the protector, is to stop certain decisions that are not in line with the family's wishes. But the protector cannot make those decisions. And the trustees still remain the port of call that can make those decisions and ensure that they are correctly implemented.
And maybe you can take us through, how many times can you change a protector? Is that something you can do during your lifetime? At what point can you no longer change the protector?
Well, generally the protector appoints his successor, and most of the trust deeds allow for that. So the protector would actually resign in favor of someone else. And the protector would also appoint potentially a successor that, should that protector either not be there anymore by virtue of some accident or death or whatever it may be, that there immediately is someone else that can step in and take over the role as being the reserve protector of that specific trust. So once the protector is appointed, we take it away from the settler. The settler can't control ideally who that protector should be. And hence why it is very important to choose the right person as the protector, someone that understands the family situation, someone that's close to the family, and someone that will look after the interest of the family.
Thank you for that, Willem. And we are going to get into some questions on the panel shortly. I don't know if there are any further comments from the panelists, or can I start looking at different questions on the back of what
I think
Willem
from our side, Sarah, I think you can start with the questions.
I do need to throw Fazeel a curveball. He hasn't had his curveball yet. So Fazeel, he's looking at you. You mentioned a South African resident who has, for most of the part, their beneficiaries in South Africa, and how the new tax regime would potentially not affect them in most instances. Do you want to maybe comment on how a South African resident would be affected if they decided in the next 10 years that they were going to close up shop here and move lock, stock and barrel to Mauritius? So let's say, for purposes of this example, they set up the Mauritian Trust. They take advice that currently there may not be any tax because there is only a portfolio held in the trust, and they decide 10 years later they are going to move offshore, and the kids decide that they are going to leave and go live in the US or the UK and all over the world.
Yeah, thanks, Sarah. We need to make the distinction between the trust being a resident trust and being a non-resident trust. To the extent that you have a trust that is a resident trust, and let me recap on the 3 criteria that are necessary for a trust to be a resident trust, and all 3 criteria have to be met at the same time. So the trust is administered in Mauritius, and a majority of the trustees are resident in Mauritius. The settler is resident in Mauritius at the time the instrument creating the trust is executed, or at such time the settler adds new property to the trust. And a majority of the beneficiaries, or the class of beneficiaries appointed under the terms of the trust, are resident in Mauritius. So if all 3 criteria are met, then the trust is considered as managed and controlled from Mauritius, and therefore resident for tax purposes in Mauritius. Now, let's say if one of the criteria is met, for example, the settler is, at the time the instrument creating the trust is executed, or at the time that they're adding property in the trust, the settler is non-resident, then all 3, one of the conditions for management and control is not met, and therefore the trust is considered still as being a non-resident trust under statement of practice. Okay, so if then the settler decides to move to Mauritius, that doesn't change the fact that it's still a non-resident trust, because at the time of settlement, the settler was non-resident. Contrast that with the situation where the South African individual moves to Mauritius and is a Mauritian resident by virtue of the amount of time spent in Mauritius or otherwise, and as a Mauritian tax resident person, then settles asset in the trust, and the beneficiaries are resident in Mauritius. And then the standard assumption that the trust is, of course, administered and managed, and the trustees are resident in Mauritius, then that trust would be considered resident in Mauritius. And the difference between the 2, as I explained before, is to the extent that the trust is not resident in Mauritius, then it's only taxed on income arising from within Mauritius, on what we call local source income. Okay, I saw one of the questions, if a trust is a non-resident trust and it generates income from South African assets, then that income is not subject to tax in Mauritius. Okay, it's considered foreign source income. So to summarize, the 4 sort of common terms that we need to understand are resident versus non-resident trust, and local source income versus foreign source income. Okay, so a non-resident trust is only subject to tax on local source income, whereas a resident trust is subject to tax on worldwide income, which is local and foreign in Mauritius.
Perfect, thank you for that. And to use the example posed previously with the beneficiaries that live all over the world, would there be any words of caution from our panel on beneficiaries that have immigrated to different countries and maybe at some point in the future they intend on getting distributions out of the Mauritian Trust?
I think maybe if I can add, I think it's always important to ensure that you consult with your trustees and tax advisors when you relocate, because there certainly is some countries that are not as friendly to trusts as others. And from recent conversations that we've jointly had, Australia and the US becomes 2 prime examples. If you are to leave South Africa and immigrate, for example, to Australia and the US, we really need to relook at what the trust looks like before you arrive on the other side, so that you can plan and structure the assets within the trust in such a way that it still remains beneficial from an overall estate planning perspective. So I think relocation, even relocating of kids or family members, becomes quite important to always ensure you go back to your advisors and get proper advice.
And just to add to that, that's preferably something that you want to plan for in advance. So if you are waiting until you have a situation like that on your hands, it's most probably too late. So the idea is the moment that you feel that there is an impending move or change like that, that you would clarify that. But what I also want to say is that I just want to give a note of caution to our listeners. A lot of this information is very generalized, and facts like these are already depicted in isolation, and absolutely any variable, however tiny, can really create different nuances. So please be sure to consult our speakers if you've got any variances in structures, and don't take what we've given you as being the sample case scenario that's applicable in all instances. Now I'm going to go to the questions that are coming up on the panel, and I see that many of the questions surround funding into the Mauritian Trust. So how do I fund? Am I donating money to the trust? Is it an investment, was the one question. The other question is, how do I loan money into the trust? Is Section 7C applicable? Or alternatively, is Section 31 transfer pricing applicable? Can I use LIBOR? I don't know which one of you wants to take this. Ernie, I can see that you're nodding over there. So I think we're going to give this one to you.
Yeah, thank you, Sarah. Happy to take it. I think you've touched on it there. First of all, you need to move your assets into the trust in a what's probably the most effective manner that you can possibly do that. One way to do it is, as you've touched on, is to do it by means of a donation or a settlement. If you do it by means of donation or settlement, you'll need to be careful, because there will be donations tax applicable. And there's also attribution rules, which basically in Section 7(8) of the Act provides that all income arising from a donation may be taxed in the hands of the original donor. There are ways, obviously many ways to structure it to ensure that you're outside of the scope of Section 7(8). And we very often have the argument that a lot of those secondary income arise as a result of the wits of the trustees and the labour of directors of an underlying entity, as opposed to the actions of the donor. But it depends from case to case, and something is quite an intricate part of the law that needs to be considered carefully. You've also got the option to loan the funds into the trust. That loan must bear interest at fair market at fair market rate. Now, there's two, and yeah, you obviously won't be surprised to hear that there's not a lot of clarity from SARS on the position, and there's two parts of the Act that you need to consider. The first part is Section 7C of the Act, which says that a loan to a trust must be loaned at the official rate of interest, being the repurchase rate or similar rate of that currency plus one. So if you're lending those funds in South African rand, it's repo plus one. If you're lending it in Swiss franc or in US dollar, you're obviously looking at what's the similar similar repurchase rate, and then you can that's obviously the similar US dollar based rate or Swiss franc based rate, the rate that you can lend the money on. However, there's also Section 31 of the Act, which says that it's a transfer pricing provision that says all transactions between affected persons, related parties, any loan from yourself to your trust needs to be at arm's length and fair market related, which very often begs the question: is the official rate of interest, as provided for in Section 7C, whether it's US dollar or just franc based, whatever it based, is that considered to be fair and market related? And we take the view that it's very often a good guideline, the official rate of interest, Section 7C, as to what SARS will consider to be fair market related, but it's not necessarily. So you need to just have, in certain circumstances, you will need to do a transfer pricing analysis. If it's unreasonable to do a transfer pricing analysis given the size of the transaction, then you just need to make sure that you're within some form of the safe harbor that SARS can't attack the interest charge on the loan.
And when sitting with a client, how would you go about advising a client? So now they've been given all these options. It must be incredibly difficult. You've been told you can donate. You've been told you've got two options on loaning. How do you guide them through this process in a simplistic manner?
So I think it depends on, like you said, I think you've touched on it before, that there's no one size fits all solution. And we very often look at it with a sit down and saying, listen, what are your circumstances? Where are you looking in terms of how, what's your age? What is your exit strategy? What is your family planning? What is your succession planning? If it's a business, is it a portfolio? How often do you want to, is it your bread and butter money that you're moving? And we then do an analysis, and very often work very closely with the financial planners or the wealth advisors, the investment managers such as yourself, is much smarter than us, can come in and say, listen, this is how we see things, and this is how the portfolio is going to grow. We then do that analysis and go, and we can then express an opinion saying, listen, we think in the circumstance, we think it's best to do it by means of loan, to do it by means of donations. This is your tax, this is what you're going to end up with. This is your tax position or the legal position that you're going to find yourself post-transaction.
So it's fair to say if any client or listener today is sitting with a practitioner that has given them the options, but they have not discussed the different tax permutations with them, whether short-term or long-term. So looking at the trigger taxes, the immediate ones payable upfront, as well as the ongoing ones, then they are most lacking in this discussion.
Yes, I agree with that.
I'm going to go to another question, and I think, Fazeel, we're going to go to you. I think this one has been asked a couple of times. How and in whose hands will distributions to beneficiaries be taxed? I think that's a brilliant question.
Yeah, distributions from the trust, from a Mauritian perspective, are considered like, if the trust is a resident trust, then they consider like, normal distributions like dividends from Mauritian companies. And because the trust is like a company under the Income Tax Act, and that's exempt from tax in Mauritius. If it's a non-resident trust distributing to non-resident persons, then it's not within the scope of the Mauritian tax rules. So we need to consider what are the implications in South Africa. And perhaps Ernie can touch on that.
Yeah, thank you, Fazeel. Yes, so if there's a distribution from a Mauritian trust to a South African resident beneficiary, there's what's referred to in South Africa as the conduit principle and the income rule, which means that the income will retain its nature. So dividends will be taxed as dividends, interest will be taxed as interest, and capital will be taxed as capital. There are certain permutations to that depending on the interest that the trust holds in an underlying company, or the nature of the assets, which is obviously needs to be qualified. But most of the times, any receipt in the hands of a South African resident beneficiary will be taxed in South Africa. It's very often, and things like if it's income that's arising from a underlying company and foreign entity, and the trust holds more than 50% of the shares in that entity, or together with connected parties hold more than 50% of the shares in that entity, then you will not qualify for the dividends, the foreign dividend exemption, and you'll be taxed. You'll only qualify for the partial exemption. So all dividends will, in such circumstances, be taxed at 20% in the hands of the South African resident beneficiary recipient of that dividend.
You mentioned the foreign dividend exemption, and I think this is an opportunistic moment to raise this question. As a South African, what is better for myself, a resident or a non-resident trust? Will I have to pay tax both in South Africa and in Mauritius if it's a resident trust? I know that this could potentially take us into the next hour, but I'm throwing this one into the middle of the ring, and whoever gets it first can answer.
I'm happy to pick up on it. So first of all, you're not allowed to the exchange control regulations are quite strict. The South African resident trust is not allowed to hold foreign assets. You can either only a company is allowed to use a foreign direct investment, or an individual can use their foreign capital allowance to take money out of the country. So you'll never find yourself in a position where you've got the South African trust holding offshore assets. Unfortunately, not allowed. That's a no-go. Your South African local assets, if that's held by a South African trust, any distributions again will be taxed in accordance with the conduit principle, either in accordance with the income tax rate of the beneficiary. If the trust doesn't pay income tax itself, it's distributed in that year. Again, when you're looking at dividends from a South African resident company, that'll be taxed at 20%. If you've got a Mauritian entity, if you've got a Mauritian trust, and again, as we've discussed before, you hold more than 50% of the underlying entity, you'll also pay 20%. I'm in South Africa, so you may find yourself where the tax consequences are very closely aligned. My recommendations, like I said, each case is unique, and we'll need to look at the actual facts and circumstances. There's 100 different scenarios that we can potentially discuss around how the taxation will work, but that's the general principle.
Right, are there any closing comments from any further panelists?
If I can go first, thank you, Sarah. I think as we've seen, the Mauritian Trust is well and truly alive and kicking. And I think that my main message is that the misconceptions that may have been created or reason through articles in the press and what have you, have perhaps created some doubt in the minds of South Africans and other persons, and those doubts are very much not justified. When we look at the practice, the similar practice, and the status of the trust today, as explained by Willem and Annie, it's a very attractive proposition still. And with Mauritius moving into the white list of the likes of FETF and the EU, I think it makes a lot of sense to consider the Mauritian trust structure, in different scenarios.
Thank you, Fazeel. We're going to be sending out the contact details of our speakers in the next day or so, in case anybody does want to get in touch with them. And to finish off, I just want to state again that whilst we really aim to simplify seemingly complex matters, please don't try to solve any queries on the basis of this very, very short summary. Rather, reach out to a specialist. For those of you who are our clients, you are welcome to contact your portfolio manager if you want to arrange a meeting with a fiduciary specialist in your area that can help you navigate your queries and to ensure that you are directed to the correct experts. But you are welcome to contact any of the speakers that are here today. We wish you all the best and we hope to see you at our next webinar. Thank you, everybody.